Good morning. This is Casey Cook with My Texas Estate Plan. I've been asked to do a short video sort of about the general aspects of estate planning and what goes in. Before I begin, I hope that everybody's doing well, staying safe during this quarantine. I understand that things are difficult at this time, and so hopefully what we talk about today, I'll be able to shed light on a few things regarding estate planning that may be beneficial to you. So I'd like to begin with, what is estate planning? Well, everyone thinks, I don't have $1 million. I don't have 2 houses. I don't have a super large income. So what do I necessarily have that would qualify as an estate? Well, an estate is going to be considered anything you have, whether it's a dollar, whether it's a house, whether it's a bank account. Anything that you have in your name is going to be considered part of your estate. So now we have to determine, what do we do with this estate? What kind of documents do we draft to have protections moving forward for our assets or for our person? And so I'm going to begin with kind of defining times in your life where estate planning would be necessary. There's nothing too sexy about either of these times in your life. Estate planning is really just about creating access during either death or incapacity. What you're going to want to do is protect yourself in the event that something has happened, whether it's inevitable or it seems to happen as an accident. So the first thing I'd like to talk about is incapacity. What is incapacity? Incapacity could be getting older. Alzheimer's, dementia is usually a leading cause for incapacity. An accident at work or on the road while you're traveling. You're not able to make decisions for yourself. Well, what do you do? What do you have in place to protect you in case this happens? A lot of times, people will elect to do what are called power of attorneys. Now, with power of attorneys, you have a financial power of attorney and you also have a medical power of attorney. These are going to be drafted in a way that if this event happens to you leading to your incapacity, you've nominated somebody to step in and to make decisions on your behalf, whether that be continue to pay your bills, access your bank account, pay for any nursing home care, anything like that. In addition, it will also include medical decisions. So whether or not you need to have this elective surgery, whether or not you need to be put on a certain medication. They'll have access to that information so they can do their due diligence before making any sort of determination regarding your finances or your medical health care decisions. So the power of attorneys are going to cover incapacity. Well, what if we don't have power of attorneys and we're already to the point of incapacity? That's okay too. There's a legal remedy for that, and it's called guardianship. Now, guardianship is usually seen as the most extreme of incapacity planning because of how severe the ramifications are for taking over someone as their guardian. They can be as extreme as the guardian losing their right to vote, their right to drive, and the person that will be over the ward, which would be the guardian, would be able to make just about every decision you possibly could without any sort of approval by the ward or the person who's incapacitated. And that means that, let's say mom or dad becomes incapacitated due to age or Alzheimer's, dementia, and we go and we get a guardianship approved through the court, and time goes on. Well, somehow mom or dad becomes better and is able to rationalize and make reasonable decisions and manage their own affairs. Well, at that point in time, since the guardianship is in place, we would actually have to go back and have the guardianship approved to be removed. They just automatically don't become able to manage their affairs again legally without the involvement of the court. I don't know too many people that would want to have to go before a judge to prove that they're capacitated again. So a lot of people elect to avoid this route, and I agree. Usually only in the most extreme cases, and by law, as an attorney that would be doing guardianships, I would have to notify you of any alternatives that we could use that may be a little more applicable and a little more reasonable, some of which are power of attorneys. So moving forward, that kind of covers the basis of incapacity. And the point of today is really to just give a general summary and understanding of the big picture estate planning documents. At some point in time, I'll do something else like this to talk about more specific aspects of it and more specific things. But as for right now, we're just going to get a general understanding. So we're going to move from incapacity now to death and managing an estate post-death. When it comes to this, there's really two testamentary instruments that are common and that you've probably heard about. One is a last will and testament, and another is a trust. There are different types of trusts, and there are different ways to draft last will and testament. So what I'm going to do is I'm going to talk to you about a revocable living trust and just a simple will and testament for right now, just so everyone can get an understanding. And for those watching right now, if you have specific questions that you kind of want me to touch on, you can either put them in the comments or send me a message if it's something personal. But let's begin talking kind of about the testamentary instruments just to get an understanding. So I'll begin with a trust. So the best way to think of a trust, and the best analogy that I like to give, is called the bucket analogy. So essentially what you're going to do is you're going to have your estate. So let's say the Casey Cook family estate. So now I have the Casey Cook family estate bucket. And in this bucket, I choose to put the title to my house, title to my bank accounts, title to my vehicles. If we have mineral rights, title to the mineral rights, any real property, anything with a title. It could be certain types of vehicles or extracurricular vehicles, jet skis, anything like that. And what happens is with that bucket, I am able to sort of navigate how I want things to be managed if something happens to me. So in my case, I'm married and I have one daughter. She is 8 months old. So at this point in time, I don't feel comfortable with her being over her own finances if something were to happen to our mother and I after she was immediately 18. That being said, I've used this bucket, if you will, to sort of set parameters around what she can do. So she can get into the corpus of the trust or the principal or any income that it produces to pay for things like her medical bills or her school, but she's not allowed to go and purchase a brand new vehicle or go on a new shopping spree or anything superfluous like that would just be outside of necessity. So this is just to take care of her within a reasonable means. And so when I put things into the trust and I retitle it, I'm doing a couple things. One, and which is usually the most important for people, is avoiding probate. So anything that is in this trust is going to be managed by trustees who I name. It could be me and my wife, and then somebody else, maybe a friend or a parent or something similar like that, a trusted advisor. And then obviously we're going to have the beneficiary, so who this is going to ultimately benefit. And so by avoiding probate, we never have to go to court. It's not public record what's in our trust, so we don't have anyone that knows the extent of what we may own. The conditions that we talked about for Josie, my daughter, her being able to get it only for necessity and not anything else like that. And a lot of times when you have a trust, people elect to put certain provisions in there that protect the heirship, if you will, of it. So the bloodline. So who's going to get it? Let's say we left everything to our daughter, and then she got remarried and left everything to her husband. Well, as soon as she passed, everything would go to husband. And let's say he got remarried and left everything to wife, which is a very common way to do wills. And then he passed. Well, now everything that I'd worked for and my wife had worked for that we had given to our daughter has now gone to someone we never intended to have any part of our estate. And so by using a trust, you're able to protect yourself in regards to distributions of any principal or income from the trust. So real quickly, I want to talk about the last thing that I'm going to talk about today, and that is the last will and testament. Last will and testaments have been around for a very long time. In summation, a last will and testament is going to be, I leave whatever I have in my estate to so-and-so, my wife. And I pass, we go to court, we file an inventory, an application, an oath, a proof of facts. We go up to the stand before the judge. I do, or whoever, whatever attorney is working with the estate, deposes a witness, usually the applicant, in order to qualify them. And then you have statutory requirements that you have to file within a certain time frame regarding the estate, and notice that you have to give to creditors and things like that. It can be very simple in Texas. One of the big drawbacks is going to court. A lot of people don't like to do that, and it can be time consuming and expensive, just because of the filing fees and the attorney's fees that you would have to pay. But there's nothing wrong with a will. If you do have a will already, that's fine. Just make sure that it is updated regularly, so your intent is reflected in the will. I typically say that in between 3 and 4 years, or 2 to 4 years, is a good time to update your documents. Usually within that time frame, someone has lost a family member, there's been something happen within a family dynamic, or they've met new people, or maybe lost touch with certain people and need to go through and change some things to update their intent and how it's presented. But these are all things that we do here, and right now I'm in our Tyler office, which is actually our main office, but I also have an office in Atlanta, Texas, where I grew up. And so it's all kind of Northeast Texas area, and we would love to sit down and talk to you about this and get together a game plan. If you guys kind of like these short, what I'll call seminars, I love doing them. I really like to get involved with viewers and listeners. So if you have questions, send them in. And moving forward, if we have certain topics that y'all want to discuss, I'd be more than happy to sit down and talk about maybe LLCs, rental properties. Medicaid is a big one, and one of our large focuses up here, protecting assets, ways to convey property so you can maintain exemptions, that sort of thing. But these are all things that we do here, and so I think I'm going to wrap it up for today. I appreciate you watching, and just comment any questions you would like to have answered or discussed, and we'll move forward from there. I hope everyone has a great day.